And without further ado, I am going to introduce our speaker tonight, Ashley Barrow. And Ashley, Sherry did send me your bio, but I do not have it at the moment.
I can do it. It's really not that important.
Ashley is going to take questions at the end of her presentation. There will be a set aside time. If you would like to put your question in the chat while the workshop is going, please feel free to do so. I can collect them and put them, or one of us can collect them and put them in a Google document to save them. And then also just keep in mind with your questions, this is a really difficult venue to answer really specific individualized questions. So following up with Ashley via email, she said she'll provide her an email address after. So just keep that in mind as you're phrasing questions. And without further ado,
You ready?
to Miss Ashley.
Okay, awesome. So I'm going to start off. I'm like a big gratitude person and celebration person. So I got a little clapping hand up there. You guys, I am so impressed by the work that you do and by your organization and professionalism. And wow, that was an impressive little meeting. So kudos. I know you are in a ginormous district, and I think it's great that you have, so many resources available, but I'm just really impressed. I'm impressed by you all, and I'm excited to be here. So, thank you for having me. Well, I'm going to get to an introduction here in a second. But the first slide says I should tell you what the title is. So I'm going to tell you the title. I usually explain I use two screens. So I'm going to look over there because that's where my PowerPoint is. My name is Ashley Barlow. I am a special education attorney in Kentucky, and I work as a special education advocate in many other states, about 47, I think. And I'm going to be talking to you tonight about the three skills that I think parents need in special education in order to be effective advocates. This is kind of like, it's not necessarily a 101 type of a presentation. It's either like 101 or it is like 500 level master's class on special education advocacy. So I call this topic IEP Power Moves, and we're going to be talking about law, services, and smart strategies. And my business here is called the Collaborative IEP. So let's see if we can advance this. Okay, that's me. I'm Ashley Barlow. I'm a special education attorney and advocate. I'm licensed in Kentucky. Oh, is somebody?
Yeah, no, that's me. Sorry.
Oh,
Are you supposed to be sharing right now? Because
can
we
you
can't see
see? Can
anything.
you see? Oh, boo. I've already messed it up.
You're fine.
As I like to tell people, nobody's perfect, including me. Okay, I'm going to minimize you guys. Okay, so can you see it now?
Yes.
Yep. Okay, good. Back to the title. The title page is so cute. It's got heels because we're powerful, and I like it. And now you missed it. Um, okay, so um, here we are. IEP Power Moves. We are going to be talking about law, services, and smart strategies. As Amanda said in the beginning, I this will take us about 45 minutes, depending on how fast I go. Sometimes I start to give examples and it goes forever. But I promise not to make it go forever. But I will be happy to stick around and answer any questions at the end. Okay, so that's me. I am Ashley Barlow. And like I said, I'm licensed to practice in Kentucky. I practice in many other states. I approach special education advocacy through many lenses because I have served many roles on the IEP team. I am a parent to a little boy that has Down syndrome. He is 14. I guess he's not so little anymore. And I'm also a former teacher. I taught German, but I'm licensed K to 12, and I have taught every grade except I should just memorize this, but I know I haven't taught fifth or sixth. So I think every grade, K to 12, all the way through actually seniors in college, except for fifth and sixth grade or something like that. And then in my former kind of first iteration of my law practice, I was a general practitioner. So I have done social security work, I've done workers' comp work, I've done a bunch of personal injury, car accident kind of stuff. I was the landslide lady in my little county for a while. Um, I've always done special education, but it wasn't my primary focus. My primary focus was actually divorce work, and I was a mediator. And so because I was a teacher, and that's what we do, one of the things that we do is we do organizational leadership. And then really kind of like negotiation strategy is organizational leadership. So basically my entire business is built on the word team and IEP team. I really believe in collaborative relationships. And so a lot of the resources that I provide over at Ashley Barlow Company, oops, we rebranded. And so this business used to be called Ashley Barlow Company. It's now called the Collaborative IEP. But they have this collaborative nature to them, and that's really intentional. So, um, Ashley Barlow Company turned into the collaborative IEP. And what I really wanted was in my special education practice, because let's see, in like 2012, probably, I decided that I was going to focus solely or very specifically on special education. And since 2021, all I've done is special education and special needs estate planning. And so it's kind of been this like big focus for about 10 years in my practice. But what I was noticing is that families had a really hard time affording attorneys and advocates to begin with, but then also kind of like taking the leap to choose an advocate. And that's different in different regions. I know in your region, it's more common just to bring an advocate to all meetings. But where I am in the middle of the country, it's not that common. And so I was getting a lot of people saying, I'm really hesitant to hire an attorney or an advocate. I'm really hesitant to invest in the cost of this, et cetera. And so I started this business in order to provide resources that were more affordable, that were readily accessible right there on the internet at all times, that kind of had my spin, that they were founded in the law, right? Because I'm a lawyer, but I can explain stuff because I'm a teacher and I like to make stuff easy to understand. And then really like empower parents so that parents really understand that they are part of a team. With this collaborative spin behind it. So that's what we do here at the Collaborative IEP. Our mission is to empower, inspire, and build confidence in IEP team members by providing free and paid resources to parents, advocates, and other people in the community that join the legal principles of special education with the interest and values of everybody at the table. And that's really kind of where we get this collaborative spirit. So before we get started, because we're talking about power moves, right? Oh, and I usually do say at the beginning of presentations, especially to big groups, I do have a version of these that is all black and white that meets accessibility standards. So if anybody wants a copy of the slides, particularly in an accessible way, shoot me an email and I'm happy to get them over to you. This yellow even kind of gives me a little bit of a headache. So I normally start when we're talking about power moves by saying that the word parent, I did a control find search in the federal law IDEA. The word parent appears in the federal law over 450 times. 450 times. And the reason for that is because before Congress does any law, they do a bunch of research. Okay. So they go in and they do a bunch of research and they figure out what needs to happen. Right. And then that goes through committee and they might bring experts in and we get testimony before committees and staffers are up all night and they're writing these big, long briefs. And it's really exciting work. And so one of the things that they started to research prior to 1975, when IDEA was initially signed, or the first iteration of what became IDEA, was that parents must be involved. When parents are involved in special education, the outcomes are better for the student. And I think a lot of us get so overwhelmed. We get so just fried. The imbalance of power is so significant between school teams and parents. However, parent rights are really important and they're very important, particularly to the outcome that the student gets. So parent is an idea over 450 times. Parent rights are obligations. It is something that is written in the law. And teamwork has to be ongoing. So I'm not just talking tonight about how to behave at the IEP table. I truly believe that in order for our kids to have great outcomes, the team, the IEP team, including the parent, needs to be communicating on a very regular and recurring basis, even for older kids. So those are kind of like three underlying concepts in this idea of IEP Power Moves. We're going to talk about the three things. We're going to talk about the law, we're going to talk about special education services, and then we're going to talk about advocacy strategies in order to get the students the special education services that you think they're entitled to under the law. So those are the three skills that I think we need in order to be effective advocates. So the first thing is, let's talk about the law. Okay, so we're going to talk about the legal basics. We are going to talk about, I'm going to start off, I'll give you a little story because I think that's interesting. A little like war story, you know? Um, and then the next little point on here is that the importance of knowing the law is not always necessarily to fight. The importance of knowing the law sometimes just helps us advocate effectively. And what I normally tell people relative to this is imagine that it's noon and you're holding up an umbrella and the sun's out. I know I am like directly before you all on that weather that comes from the west. I'm basically in Cincinnati. And so I know we haven't seen the sun in a second. Or maybe yesterday we did, but we haven't seen the sun much, right? But let's pretend that it's May and we've done our April showers and we're holding up an umbrella. And I always say that that umbrella is going to cast a shadow. Well, when we look at a law, when we look at any provision and idea, there is going to be a framework underneath that shadow that is kind of like what's reasonable. So no law or very few laws are like, you have to do this, this is right or wrong. Laws are interpreted with all kinds of facts and scenarios around them because real life is happening outside of the laws. And what cases do, when cases go to court, they get written up. You know, you get this decision from the court. The cases help us to compare the facts in our case to the facts in hundreds or thousands, or at least one other case that's happened in the past. And if there isn't something that's similar enough to your case, that might be something that's great to go up to the Supreme Court. So we look at this shadow then of the law and we interpret things based on kind of this like casting of what's reasonable or what has been done in the past by way of legal precedent or this shadow of the law. Okay. So when we are advocating, we're kind of like trying to get a little bit here and a little bit there and a little bit here and a little bit there. And we're trying to shift the law to our advantage so that then we can get either a decision or an agreement that works for works to the benefit of the child. Namely, in this section, we're going to talk about the pillars of idea. We're going to talk about how policy and guidance impact decision making. And then number 3, we're going to talk about how to use the knowledge of the law in order to advocate effectively. And that's really what the third section is about. But story time. So I sat through, probably 3 years of IEP meetings myself before I read Kentucky's parent rights. And then I like for my own child, right? Like I had never read the parent rights as a parent. Of course, I had read them as an attorney, but I had sat through tons of them. And I had this client that came in and she had this list of literally 13 things that she wanted to accomplish at a meeting. Well, she called me before the meeting and she said, my entire house is throwing up. And I was like, oh gosh. I said, well, and this was kind of an urgent thing. So I said, would you like for me to go to the meeting? And she said, yes, I think you should go and I'm going to stay home and you can text me during the meeting and give me updates, ask me questions and whatever. Well, I ended up getting 13 out of 14 things that she asked because she didn't just stop at 13. So this was a case about some services to support this child behaviorally that she wanted to get done. And so we went through, A, B, C, D, and E, and everything was going great. And then we got to the one thing where the school just was not going to agree. Like they were a dead set no. And so I'm texting her, during the meeting, and this was the agreement with the district, was that I was going to be texting her, and then, the meeting might go a little bit slowly, but that's the way we wanted to get it done. And she texted and said, "Hey, while I've been sitting here waiting for, you to text me back, I've been reading through that parent rights document. And, they offer it to you at the beginning of every meeting. And I found when I've been reading it, and it says I've got a right to an independent educational evaluation. So we could disagree with what the district said about X, Y, and Z, and they have to pay for it." And I said, "You know what? You're right. That is not something that we had prepared for, because we hadn't prepared for them to say no there." And I said, "You are absolutely right." And so we asked for an IEE, which you are able to do under the law, under the circumstances that she texted to me, and we got it done. So and I think that the availability of an IEE is a perfect example that can save you literally thousands, if not more, dollars in your advocacy. Knowing the law can be super simple. That's not, contentious, or it doesn't have a whole lot of destructive conflict to simply say, "You know what, we agree with this portion of your evaluation, and we're going to ask for an IEE, and that you pay for it." And then you work through that process. So the legal basics. Now, I am not going to tell you the legal basis because that would take forever. I'm actually, I have a podcast, and in the podcast, we're taking a little break from the series, but I am going through IDEA, literally section by section, in the podcast. We'll go back to it in a week or two, because so many people have said to me, "I want like nitty gritty special education law right now." So we're 2 episodes into it right now. But what I'm rather going to do in this section is I am going to tell you a lot about what laws and policy documents and stuff exist. And then we're going to hop out of this PowerPoint for a second, and we're going to look at where some of those things are, so that at least you have the tools to go out and get them, right? So that you can advocate under the shadow of the law yourself. Okay, so this is probably review at the beginning. Of course, there's a few laws that impact special education. You know about IDEA, that's our federal law that impacts special education. Then there's Section 504 of the Rehabilitation Act, which is under scrutiny right now. And we can talk. I have really kept on top of these changes that are happening and that are threatened to happen. And I'm happy to talk about those at the end as well, if you have any desire to do so. The ADA, the Americans with Disabilities Act, has provided some supports to students at schools. And then there's regulations. So at both federal and state regulation or levels, regulations tease out laws. So they go into a little bit more detail, and they give us a little bit more information than laws. So regulations are written by the agency. In our case, most of the regulations that impact us are written by the Department of Education. So we have the Department of Ed regulations. Then we have these federal policy documents and federal guidance. We also get that at the state level. They have an asterisk because they are not legally binding. Courts don't have to follow them, but they really help us to make the argument. And I'm going to show you some examples of those. And of course, we have case law. So I just talked about case law. It helps us to, kind of pick out the facts that happened to Johnny in Texas and then compare them to Susie in Idaho. And then we've got state laws, state documents, and local policies. So let's look at some examples of what those things might look like. So in IDEA, now I always tell people that I highly recommend that you Google this stuff rather than write down these websites. I'm happy to put the websites in the chat. However, I am here to say that they move around and that the pages look different. And within one administration, it'll happen like 6 times where everything's in a different place and you had something tabbed and it's gone. So I just now Google it in order to find it. But IDEA, the federal law, is on several websites. Cornell also has a great spot for laws, and I always trust Cornell's. I think they keep it up to date. But the federal government houses IDEA, and you can see subchapter B or 2, for example, is where we get our FAPE provisions and that kind of thing. So that is on it's ed.gov, like literally the Department of Ed's website. The Department of Ed also has a subdivision called OSERS, Office of Special Education and Rehabilitative Services. You've probably heard a little bit about it in the news recently. And underneath OSERS is another department called OSEP, Office of Special Education Programs. OSEP has these policies. OSERS has some as well. This is the page where we get policy documents and dear colleague letters. So let's talk about those. Actually, I've got one up as an example to show you. Okay, so this is one that we got right at the end of President Biden's administration in January of 2025. And it is called Building and Sustaining Inclusive Educational Practices. So there is this really long guidance document. I'm not going to click on it, but it's like 40 something pages. And it's basically about how 2 laws. I started reading it right when it came out and I've forgotten it because everything went so quickly. But how 2 laws are available. Oh, it's ESSA, how that's No Child Left Behind, what it is now. So how ESSA and IDEA protect students with disabilities and how to use those in arguments, right? But then we also get this dear colleague letter. So people write into the Department of Ed and they say, hey, help us. Either a district is interpreting something this way, or I've run into this theme several times across the state or across my entire federal district or whatever, help us. And then the Department of Education will write them and say, here's how we interpret this. And a lot of times they are referencing, whether it's laws or it's regulations or it's case law or something like that. And again, it's not binding, but it really does help you make your argument. So policy documents are more about like, here's how to do inclusion well, or here's how to test for a specific learning disability. And then these dear colleague letters answer questions from real Americans that have written them and asked real questions, which is just crazy that you can write them and they answer you. A few more resources I wanted to show you. Google Scholar is something, Pete Wright talks about this a lot. I'm going to show you a couple of Pete Wright's books here in a second. It's scholar.google.com. And you can go into it, and I don't think we'll lose our search if we do this. So you can go into it, and it looks like this. And you can say that you either want articles or case law. And then I kind of narrowed a search. So in parentheses, so that I get it as a phrase, I have Individuals with Disabilities Education Act, and then I have an ampersand and least restrictive environment, also all together. If it weren't in quotes, you would get everything that had the word least, the word restrictive, and the word environment. I could do that, but we don't want to spend the time to do it and see how many more results we get. So this shows us all of the cases on LRE that are in Google Scholar right now. Now, it's not super perfect. It's not like Westlaw or Lexi or something like some other legal search engine, but it gives you really good information. And so you can go back and look. And how do you know? Well, Rowley's the first one on there. And Rowley is a seminal case from the United States Supreme Court. So that's super helpful. You can also narrow the search. So you can go to federal courts, and then you can select your courts, and you can say that you only want, for example, the Sixth Circuit. I thought you guys were in the Sixth. What circuit is Virginia in? Oh, I'm wrong. Virgin Islands.
Maybe?
Fourth? Let's look. Yeah, here you are. You're in the Fourth Circuit. So we could unclick the other things, and then we would, only leave the Sixth Circuit clicked, and then it would tell us what else we had. Okay, so that's pretty fun as well. I'm clicking out of these things because my internet's probably like getting a cramp. Okay. Another thing I told you about was state resources. So your local, states are going to have resources as well. I practice law in Kentucky, and something that I use on at least a weekly basis are the evaluation and eligibility forms on the State Department of Ed's website. So if I've got somebody that's going to be evaluated, for example, for a suspected specific learning disability, then I'm going to pull up the form from the website and I'm going to go through the actual form that is used at the IEP team meeting so that my clients know what decisions they're going to be making in advance of the meeting. Right. And this is something that you can ask for. You can say, are there any forms that are going to be used? Could you provide me with the form or the link to the form? And that's super helpful. So we can look through those things. Now, something that you'll see here is this, is it a severe discrepancy or is there a response to intervention model? Like, how are we going to go for eligibility? Well, if that is like a foreign language to you, then what you would do is you would go back into the Department of Ed's website and you would just search those things. And then you would find that there's policy documents that talk about eligibility for a specific learning disability like dyslexia, dysgraphia, dyscalculia. And then you would read that policy document and then you would be informed, right? And for the most part, these things are written in plain language. But I have helped people to read them more accessibly by copying and pasting several paragraphs in a row and asking ChatGPT to put it at a different reading level or in more plain language or something else like that. And ChatGPT has helped significantly on that. Okay, so that's your local stuff. And then I can't tell you how often I am in a handbook, and I should have pulled up Fairfax County's student handbook. And maybe all of your high schools or middle schools have their own handbooks. But I mean, especially if it's a disciplinary matter, handbook. I have pulled up handbooks in inclusion cases. I pull them up all the time because the words of the district can be extremely, extremely helpful. And I'm certain in a district you're the size of yours, you're going to have things that are going to support special education services and policies and, kind of like, here's how we do things. And those things can be super duper helpful. Okay. So back to the presentation, I've got a couple more tabs up for you guys, but we're going to go back into our presentation. Okay. So those are our laws and other helpful things that impact special education. So let's talk about the pillars to IDEA. Again, we aren't going to go into these things, but the federal law, this is the law that provides us the most comprehensive ideas in special education law. So this idea of a free, appropriate public education, that is something that we're entitled to. And most of the litigation centers on what's appropriate. Are the services that the school is providing appropriate? And we're going to get into some of those things in some of our examples here in a second. The least restrictive environment provision. This kind of gives us that continuum of special education placements, whether we are in full general education placement, or we're in general education with some pull out, or we go to a special class or a special school, or all the way down to home placement and institutionalization. That is one of the pillars to the federal law. So we're going to have a lot of case law on it. We're going to have a lot of policy documents on it. We're going to have a lot of information about educational placement. The IEP document obviously is a pillar to IDEA, and all of the different components to the IEP and all of the different things that have to be in there are codified in that federal law. Then we get a lot of information, as I alluded to in the beginning, about parent participation and student participation. So, that's another huge pillar, like foundational component to the federal law. And finally, we learn about procedural safeguards and dispute resolution. So now we're talking about what do we do when we disagree? For example, the right to file due process, the right to be able to file a state complaint. Those things are codified. They are found in the law in IDEA. Okay, all of this is probably like, yeah, we know that. So let me give you some things about the law that might be helpful. So how to read a law. You see a law, and it's a lot of words. right? This is just a lot of words. I look at that and I'm like, I don't know how to read it. So I'm going to help you make this make sense. So step one, you're going to read the law the entire way through. Step two, you are going to break it into small sections. And then you are going to read it again, and you're going to look for the elements. Every law has an element. In law school, the very first day, actually, before it even starts, they make you go. Super dumb. And you go to like pre-law school and you learn the acronym IRAC, IRAQ, issue, rule, application, conclusion. And you do that for 3 years straight. What is the issue in this case? What is the rule? The rule has elements. So you say a person is guilty of kidnapping if they A, have a kid, and B, napped him. Those are the two elements to kidnapping, right? So then we apply A, the facts of that situation to the rule. There was a kid, he got napped. And the conclusion is, therefore, the kid got kidnapped. Okay? So we're looking for the elements. We can't do that when there's so many words. So what do? We break it down. I have broken this law down by hitting 2 keys on my keyboard, Enter and Tab. So we're going to go back to the wordy one, and I'm going to show you what I did. What this statute, this is a regulation in Kentucky, and it is how to determine if a student with an SLD, dyslexia, dysgraphia, dyscalculia, CAPD, go on, is eligible as a student with a disability in the state of Kentucky. So this is a portion of a really big piece of the law. But what it says is the ARC, that's the IEP team, can determine that a child has a specific learning disability if. Okay. So 3 is like a part of a different component of the law, right? So we can ignore that. But I have gotten to this A, parentheses, A, parentheses. What I'm going to do is I'm going to hit enter there. And then I'm going to assume that there is a B, parentheses, B. Sorry, parentheses, B, parentheses. And maybe a C, and maybe a D, and maybe an E. All I have here for you is A, because it's all that fits on a page naturally. But don't worry, we have enough with an A that it'll be fine. So right after A, we get this nice 1. So I'm going to hit enter indent, and I'm going to get 1. And then later, I'm going to find the 2, and I'm going to hit enter indent. And then under 2, we have A through H. And now you see that I can follow this law really easily because under A, a child has to be provided with learning experiences and instruction appropriate for the child's age. And the child doesn't achieve adequately in one of these areas that's A through H, 1 or more. So we have to prove 1 and 2, but under 2, we only need one of those things. Now we know our elements. Now we know what we have to prove. So now we can go into the IEP meeting and we can very objectively use this information and plug it into the formula. Take our little Johnny and plug him into the formula. And it's like magic in our hands. So what we can do then is we can be objective at the IEP table. If there's one problem that parents make, myself included, it's that we get too subjective. We get into this like, well, this isn't fair, or I just feel like this really subjective thing. And so now we can reference the law and we can be objective. Also, another thing that we can do is we can ask the school for the things that they have in writing. So if they say we don't do it that way, you say, oh, well, could I please have that policy? Where is that policy located on the website? Is that something you could print off for me? That would be super helpful. If maybe you could show that to me and we can meet in 24 hours. Also, prior written notice. So some things have to be in writing. Some decisions under the law have to be in writing. So if they make a decision and you don't agree with it, you say, can we just make sure that we put that in the prior written notice? In Kentucky, they're called conference summaries. And I say very often, so as long as that's in the conference summary, I think we're ready to move on, right? Because then I'm just saying, I want the prior written notice and then we're going to deal with that later. Um, Obviously, you can leverage that guidance. And again, don't forget, the guidance is not legally enforceable, but it can help you to build your argument because it gives you the elements, it gives you the laws and the regulations, it gives you all of the stuff, and you can use it to then make the arguments. Um, and then, kind of like a big key here is that attorneys do not hear the word no and say, okay, well, then it's conversation over. Advocates don't hear the word no and just completely give up. When we hear the word no, what we should be doing is we should be looking at it as an opportunity to reframe things and to see if we can move within that shadow of the law. So we can look at other possibilities. We can kind of go towards teamwork and more collaborative strategies in order to get us to a yes. And I've got all kinds of ideas relative to that in a second. First, I want to tell you, so I'm not like trying to sell a product at all. But this next slide is from this product that I have that's called IEP Guru Academy. They're really short videos, like 20 minutes or less. I say I can teach you one topic and the amount of time it takes you to drink a cup of coffee. And so this one is called What Do You Do When the School Team Says We Just Don't Do It That Way? Right? Like that's a hard no. What do we get to? So my quote is a no is simply a signal to think creatively and keep looking for a yes. Every problem has a solution. Sometimes it just takes a bit more collaboration to find it. I call this relentless optimism. I'm like, okay, well, let's see if we can keep going. Okay, how can we think about this differently? Right? And so just kind of moving the needle forward. So then we need to talk about special education services. First thing we need to know is the law and kind of the framework of the law. The next thing that we need to know is about special education services. So, a big question would be, what are we even talking about relative to services? And then how do I figure out what services are appropriate for my child? So in this section, we're talking about understanding and advocating for the right supports. We'll start with a story. So my own son has Down syndrome. He was an emerging reader for a really long time. And God bless him, he was so patient. He really wanted to learn how to read. But we just couldn't figure out what was going to work for him. And the problem I found out was that his special educator had been trained in Norton Gillingham, but didn't have a curriculum to follow. She just had like OG principles, but she didn't have something that she could follow with that systematic component that is kind of a hallmark of a good OG program. And so during the pandemic, I had him home, which is a totally different thing, but I had him home for 18 months. And I thought, well, I'm a teacher and I've got him. So I'm going to get trained in an OG program. And so I got trained in a program it's Lindamood Bell is the company, and then the program is LIPS. Well, I was like halfway through the training and I thought there is no way that this will work for Jack Barlow because it is really, really, really dependent on body awareness. And Jack has very little body awareness. And I thought, gosh, if I had done this for like 90 kids ahead of Jack, I could probably modify it enough that we could do this. But at the moment, I went ahead and finished the training and I was like, this will not work. And so we went another year. And then for like professional reasons, I got trained by IMSE, Institute of Multisensory Education, and became like an Orton Gillingham tutor. I tutored 4 kids one summer. And then I also tutored Jack. Jack has come up 1.5 grade levels in like 8 months in reading because that was such a ginormous, like foot on the gas thing for him. It just clicked. It just worked. And the reason it worked was because I understood enough to have better conversations at school. His teacher in middle school she uses an OG program. She doesn't use the same one that I use. But because I knew enough to then really collaborate and coordinate services at school, we finally got the click. A lot of other things happened. I don't think it was just because I got trained, but my knowledge really helped us to be able to make that progress. So I think it's super important that we know enough to be dangerous about the actual programming that our kids get. So a little bit of a myth, of course, special education is not a place. It's a set of services, including specially designed instruction. And we're going to talk about that here in a second, that is delivered based on individual needs. So we're going to talk about SDI, specially designed instruction. We're going to talk about other modifications, accommodations, and services that our students need. And then we're going to talk about advocacy strategies in order to get the right services. So, special education is in the definitions of IDEA, and it is defined as specially designed instruction that is designed to meet the unique needs of the child with the disability. So, when we look at special education, what we are supposed to do is we are supposed to look at the unique needs of the child. I call this their learning profile. What is their profile? Are they like, I've got a child who is neurotypical, who has like super, super good verbal comprehension. I mean, he is oral comprehension. Like he can hear something and he's like, yeah, I got it. But his processing speed is relatively not as strong. And so what happens is he hears something, but then he can't retain it in his working memory. So he's super confident. And then he goes to take a test and he doesn't feel like he has to review stuff. And then he gets an 80 out of 100 on the test. That's part of his profile. So he needs something where he can hear it and he can review it and he can hear it and he can review it and he can commit it into his working memory. So when he looks at materials, we're really working more on retention than we are on understanding, because he can understand it just like that, right? We all have different profiles. Jack, my child with Down syndrome, is stereotypical of kids with Down syndrome, super strong visual learner. So if I put something in front of him, he usually can like pick it up. He can do a puzzle super quickly. He beats me at memory like you wouldn't believe, because his visual processing is so good and mine is terrible. So we look at what specially designed instruction is, right? It is adapting as appropriate to the needs of the eligible child, the content, methodology, and delivery of the instruction. Okay, that's the definition in IDEA. And then it's got those two goals, which we talked about. We talked about the first one, the unique needs. The second one is to also make the general education curriculum accessible to them. So remember that the specially designed instruction helps us to make progress on our goals. So often, folks focus on the goals so much. And my suggestion a lot of times is, whoa, let's not look at the goals. Let's look at the present levels. Let's dive back into those evaluations. Let's look at the progress of how they're doing on their IEPs. Let's look at their like curricular assessments like STAR and MAP testing and that kind of stuff. And let's see where we have deficits. Now, let's say what program or curriculum, what kind of instruction, what kind of specially designed instruction is going to help them to make meaningful progress, and what curriculum is going to be uniquely tailored to their particular learning profile, right? That's special education. Then how can we make the gen ed curriculum accessible to them? Do we need to modify the content? Do we need to whatever we're going to do? Okay. So that is the education. So students are entitled, therefore, to access to the gen ed curriculum as modified, and those modifications and accommodations go in supplementary aids and services, special factors, other places of the IEP. They're entitled to that specially designed instruction. I'm not going to beat that dead horse. And then they're also entitled to related services like our OT, PT, orientation and mobility, speech, those things, and then supports to address the special factors like behavior, assistive technology, etc. So, how do we choose a curriculum? How do we know what curriculum is going to work? First of all, is it individualized? Second of all, let's look at the research. Is it evidence-based? Is it research-based? IDEA says that it has to be evidence-based. Um, let's see. Is it the same as Gen Ed? I can't tell you how many times I ask. A huge question that I ask in IEP meetings is, well, what are you doing for specially designed instruction? And I can't tell you how many times the special educator doesn't know, especially in upper grade levels. A lot of times what they say is like, well, they don't come to me and ask questions. Or you can tell that they're just helping with homework, like helping them keep caught up. And so I'll have to say, okay, well, what curriculum are you using? And, kind of one example that I heard that describes a lot of these things is, well, I use whatever the district gives me. And I'm like, well, what's that? What's that mean? Like, do you open up page 25 of a book on Monday and then do you go to page 27 on Tuesday? And she just kind of looked at me blankly. And I said, well, then how is it uniquely tailored to this child? And they couldn't answer it. And so, going back into the curriculum and asking those, or into the curriculum and asking those questions can be super powerful and kind of help hammer home what it is. I don't think I told you, but I also have a physical disability and I'm really fidgety. I have a broken back and I broke it when I was a kid. So it's just deliciously uncomfortable from time to time. Okay. So it can't be the same as the general education curriculum. Um, and it needs to be integrated into the IEP. Like it actually has to address goals and we have to take progress on it to see if it's working. We have to look at our return on investment. And then, of course, documentation and justification that it's right? So okay. And then, I should have pulled this one up. This one should have gone earlier. Sorry. What's the child's profile? So objective strengths and weaknesses from evaluation reports. We're going to go fast because I did this without a thing. Also, don't forget, though, that you might have a subjective or gut feeling on skills or generalization of skills, and that is important too. You might say, what's an example? Like, okay, what if it's like, I know a skill right now. My son he hates math. He hates math calculation, but he's pretty good at like doing a word problem. And, let's say it involves money. And the question is, can you afford the Nerf gun? Well, if it's can you afford something that you want, the answer is always going to be yes. Now, he can do that pretty well in school so long as they just choose stuff that he doesn't care about. So he does pretty well. When I go out and we try to generalize that at TJ Maxx or at Target, he doesn't do as well with it because it's real life then. And that makes it hard for him to generalize that skill, right? So sometimes generalization is just that easy. And in his case, it's truly emotion that gets in the way of it. But that's important too. Then, of course, medical and developmental information comes into your learning profile. Obviously, we talked about progress monitoring data and then services that you need as a result of that information. Okay, so before we do these advocacy strategies, I just want to give you a couple of resources here. You might know about the What Works Clearinghouse. So within the Department of Ed, if you look up at this website, we are still in ed.gov, but there is a little subdivision called the Institute of Education Sciences. And this is one of the research arms of the Department of Ed. And one of the things that they have is this What Works Clearinghouse. So within What Works Clearinghouse, you can search particular curricula. So you could search, for example, UFly, which is the University of Florida's Literacy Institute. And it is something that is being used a lot in schools. It's free and it's become pretty common. Well, UFly is not coming up within the What Works Clearinghouse. But you could search Wilson, which is a different program that is evidence-based and is Orton Gillingham compliant. And it's in the What Works Clearinghouse, and it will tell you how, like, so this is tier 3, this Wilson reading program, which is the beginning level. Tier 3, promising good results, evidence-based program. Okay, so that's super duper helpful. I wanted to show you that, the What Works Clearinghouse. And then I also wanted to show you, this is also on that website. There is a spot where you can pull up research articles. And so just for an example, I put UFly back in there. And here are, it says it has 7 results about UFly. So here is research that was done on UFly. And here's one from 2010, evaluating the effects of the University of Florida literacy. Oh, it's an initiative. I thought it was institute. On Spanish speaking ELLs. Okay. And so then you would get that article and you just click on it and it comes up. All right. So I just wanted to show you that because that's another way to get good information about curricula. Okay. And then finally in this topic, back to present, I wanted to show you advocacy strategies for getting those right services before we move over to general advocacy strategies. First of all is let's make decisions based on data. Let's look at that evaluation data, look at the progress monitoring, look at those things that we talked about, make decisions based on that. Also, and that involves using evaluations to support your case, right? Another huge thing that I recommend is working with your child on their IEP goals at home. It doesn't have to look just like school. It shouldn't look just like it does at school. But when you work with them, you will get big aha moments. And those aha moments will help you then to participate better in meetings, to write emails, to communicate, to collaborate with school. The example that I give of this that seems to land fairly well is when my child was in kindergarten, he had a goal of rote counting. And I was pretty sure that he could rote count, but articulation was getting in the way. So he would get to 9, 10, 11, 12, 13, 13, 13, 13, 13, 17, 13, 13, 20. And I was like, okay, so what we have to do is we have to count the 13s until we get to ebentine and see if that counts for 13, 14, 15, 16. And it was inconsistent. So I'm like, I don't know if he is. I think he's just saying 13 and then he throws in an ebentine, 17. And then eventually we get to 20. And so what I started to do was I started to give him the numbers, the actual numerals, and he would put them in order and he could do it. And I was like, yes. So not only that, but he was getting the correspondence between the numeral and the number. And I was like, Eureka, he can count, right? So then I went to school. His data was bad on rote counting. And I said, listen, I think he's bored of this because he's been working on it. You know, that's a skill that you work on from birth forward. And B, I know he can do it because here's a little video where he's doing this and he's doing this with consistency. And they're like, oh yeah, good idea, right? So we work together. Now, of course, it gets more complicated as life goes on, but I continue to work with my child and he is in 8th grade. Of course, not all services are one size fits all. A lot of it's trial and error, but the data drives the instruction. So yes, of course, in the beginning, we are really kind of trying something. And then we're going to reevaluate whether it is working. We look at the data and the data is going to tell us if it's working pretty quickly, honestly, which is why I also sometimes do a trial period. I'll say, okay, great. I think we should change the reading. We all think we should change the reading program. Let's get together in 3 months and see what the data looks like. 4 months, how long do you think? And then we'll reevaluate, right? Because we don't have to go a whole year before we make changes. Okay. Now, how do I inform? Oh, when we talked about the law, I didn't do my books. I didn't show you my books. Okay. So how do you get informed on stuff like curricula? Because I think this is intimidating. I think knowing curricula is intimidating, and I understand it. And listen, I'm not saying that I think you need to know every piece of it, but I think tootling around on the website for the curriculum could be extremely, extremely helpful. So groups like yours, this SEPTA is super, super helpful. Trainings like this one that you're in, talking to your friends, talking to colleagues, books, the websites, attorneys and advocates. I think all of those people can help. I meant to show you a couple of books about the law that I think are helpful. You probably know Pete Wright, Wright. He has an awesome website called rightslaw.com. He has all of IDEA codified in a book. It's called Special Education Law. And so there's a fourth edition that came out. I reviewed it and I think it's out already. If not, it should be out soon. Then he and his wife wrote this amazing book called From Emotions to Advocacy that gives really good advocacy strategy. I think it is super helpful on our next topic about advocacy. And while we are in the law, my favorite law book that's like a textbook, like a law school kind of textbook or like master's level for teachers kind of textbook is called Special Education in the Law. And the author is Allen with two L's, Allan Osborne Jr. and Charles Russo, Russo. I think this one's super helpful and also pretty easy to read. So we're going to talk about advocacy strategies. And this will go a little bit faster than you think because we've talked about a lot of them already. So let's skip story time because we're a little bit over time. And we've got that same myth in there. Oh no, this is an old slide. I was like, why is it the same? Okay, well, we're just going to dive in and we aren't going to get the I don't know, I don't know what happened, but we're moving on. Okay, so as I alluded to before, in special education, it is completely normal to experience all of these feelings and emotions as a parent. We are extremely overwhelmed. We are very emotionally invested. We don't care about anything like we care about our kids. And for a lot of us, education is extremely, extremely important. In the process, somehow a lot of us feel unheard, at least at one time. There's a humongous imbalance of power. So we feel outmatched. We feel, therefore, very defensive and frustrated. And those are all feelings that are very, very normal. But if we know the framework of the law and if we know services that we think our children should be entitled to, we should be able to advocate effectively for them. So these are a couple of slides from another IEP Guru Academy video called Finding the Middle Ground. It's about negotiation, teamwork, and my brain stops working at about 9:00 and we're almost there. Negotiation. Oh, and advocacy. Duh. And we're going to talk about the difference between all three of those here in a second. So knowing where to push, knowing where to stand firm, and knowing when to compromise can help you not only achieve better outcomes for your child, but can also build more collaborative relationships within the school team. And that's a huge key here. So, what is the difference between advocacy, negotiation, and compromise? I think there's a place for all three of these things at the IEP table. And just to be super clear, I also think that there is a place for true dispute resolution as well. Advocacy is when you don't move off your place. You are just out there and you are shouting the worth and you are saying what your child needs. So it's focused solely on the child's best interest and ensuring their legal rights. This is you saying, my child that has diabetes is entitled to have Skittles in their classroom, and there is no saying anything else. My child that has autism is entitled to their private BCBA coming to school, and there is no room for anything else, right? You are advocating. Playground accessibility, website accessibility, we don't have any room to wiggle. Okay. Then we have negotiation. Negotiation is looking for a win-win. So in negotiation, what we're doing is if one side's here and one side's here, probably both sides are going to move a little bit towards an agreement. Negotiation obviously takes a lot of active listening. It takes a lot of collaboration strategies. Both sides are going to propose some kind of solution. You know, what about if you did this? Well, what about if you did that? Okay. And now can we meet in the middle? Right. So it involves this collaborative kind of teamworky thing. And then compromise is really saying, here's my list of what I want. And, you know, I've prioritized them and I'm willing to let go of a couple of things on the bottom in order to get a couple of things that I prioritize higher. So at some point in compromise, probably both parties are going to give up on something that they don't care as much about or something that they've like figured out how to not care as much about in order to get some of the more important things done. So it focuses really kind of on keeping the process moving. And a lot of times with compromise, it's like the last thing at the end where you're like, okay, fine. If you do that, you know what? We'll hold off on this. Or we'll agree to wait 4 weeks until we talk about whatever. Compromise is tricky at the IEP table. But if there is some flexibility, it can really just kind of keep the ball rolling and keep things going through the process. So 3 big strategies. This is in the IEP Guru Academy. This has 6 strategies. So I chose my favorite 3 that we could share in a kind of broader sense. The first one is don't be afraid to use bold statements. Like if I'm in an inclusion case, I mean, I'm doing it right now. My kid, they've agreed to keep him on diploma track in 9th grade. And it's something that they really haven't ever tried for a student whose needs are as significant as my child's needs by way of modifications to gen ed. And I said to him, listen, if this does not work, I will take him off of diploma track. He does not need a high school diploma to do what I think he's going to do for employment and future education. That is a very bold statement. But I wanted to set the line right there so that they knew and there was no like hesitancy. Now, my IEP team has a lot of trust and I have a lot of trust in my district and I'm in a very small district. And so I have the luxury of being able to say those things. But I have fought tooth and nail in order to have the privilege of saying those things. Similarly, I said to an attorney today, yeah, that's not going to happen. My client will never agree to that. I do think I could get her to here, but she's never going to get there. And later on in that conversation, he said, you know what, Ashley, you said this, and I'm going to say that this is never going to happen. And we went there. So, you know, these bold statements help us to kind of set the parameters so that we know that we aren't going to go there. And then we don't have to. We don't have to go through the rigmarole. Shifting the credit. So this is a strategy that you probably use with your children, but somehow getting people to get to the water and to drink from it and to think it's their own idea can be extremely effective. So you shift the credit. I just did it with somebody not too long ago where I was like, well, it was actually your idea. And, you know, at some point they had said something that I was like, you know what, that's a really good point. Maybe we can do it this way. And then we circled back to it and they said, oh, well, maybe we could do blah, blah, blah. And I was like, yeah, that's what you said. That was actually your idea. So it can be effective even if it takes a second to circle back to. And then another strategy that is so often overlooked is starting where you agree. Start with the things that are super low hanging fruit, that are really easy to get, and then build momentum from there. This is great. We agree on this. We agree on that. We agree on this. We are doing a really good job. And then you build momentum into the more challenging or complex issues. Okay. So that's what I've got for you today. I have a membership if you're interested in that. And then I usually do like to give a little bit more about my business just so you know where to find me. So everywhere on social media, the business is called at the Collaborative IEP. So at the Collaborative IEP. Um, I've got the membership. I have a conference. It's actually this week. It's free. All day Wednesday, Thursday, and Friday. You get 24-hour access to the Wednesday sessions on Wednesday for free, Thursday sessions on Thursday for free. You know, the thing for Friday. But there's a VIP pass if you can't attend on Wednesday, Thursday, or Friday. So that's on the website. The podcast is called the Collaborative IEP Podcast. I did just do a special education or a special episode on the changes and kind of like the threatened changes in the Department of Ed that is getting good feedback. So that's there. The IEP Guru Academy videos. I have 2 digital courses. If you're interested in becoming an advocate, this one, Advocacy, Business, and Concepts, can help you to get started as an advocate. And then I have a tutoring and consulting business as well. So those are our products. And we can unshare here and get to some questions. Oh, stop share. That's where it is. Okay. I hope that was helpful. I have not given this presentation too many times, so I'm not in a super good flow, but I thought it could be helpful. Yes, I will get slides to you. I see that in the chat. Amanda, how do we want to do this?
Well, we have at least one question that came in. I think we have 2 actually questions or comments. Anybody else in the meeting still who has a question, please feel free to raise your hand. I can help facilitate order if that's helpful, Ashley, or you can control that.
You just want for me to read what's in the, I see 2 in the slide. I can read them.
I've got the one about there are attorneys general that are claiming Section 504 is unconstitutional. What's the likelihood that 504 gets struck down? And what other laws are available, which we covered a little bit in the.
Yeah, so there are attorneys general. There are currently 17 states that have filed a lawsuit against the federal government. The case is called Texas versus Becerra. So here's what happened in that case. So when Biden was in office, okay, first of all, what does 504 do? Section 504 of the Rehabilitation Act is an anti-discrimination law. So for us in school, what it does is it says that schools cannot discriminate against students on the basis of their disability. So I usually use the example of a child with diabetes. If the school says no food in our entire school, we are a no food school, and a child with diabetes goes to that school, well, they would be discriminated against and not able to attend that school if they needed food in order to control their blood sugar. So they could get a 504 plan that says that they can have access to food, even though the school-wide policy has no food, right? So 504 protects several classes, several different people, groups of people from discrimination, including, as of recently, transgender people. So the Biden administration added transgender people to the protected classes in 504. And so attorneys general, that's a really kind of sexy topic, right? That's a topic that gets a lot of attention right now. And so these attorneys general had, maybe advocates coming to them or even other attorneys general saying, gosh, 504 shouldn't protect this group of people. Now, side note, a big problem that the disability community has faced since the beginning of time is that oftentimes laws that protect people with disabilities also protect other people, namely, as it applies to Social Security and Medicaid, the impoverished. And so we'll see these laws coming out that say well, in order to have access to blah, 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 whether it's Social Security, Medicaid, or even some spinoff of those, you're going to have to work. You're going to have to, not be so lazy. And then the disability community is like, hello, don't forget about us. We aren't able to work, right? And so and that is really mincing words there. But I think what happened with 504 was that, and I'll tell you why I think that, was that these attorneys general got so hung up on the LGBTQ plus classes of people that 504 currently protects and kind of didn't pay any bit of attention to the other groups of people that 504 impacted because you all and the rest of us, like, a lot of people started making a big stink about it. So we all saw it on social media and we saw it in the news and we saw it on our disability groups pages and in their newsletters, right? Like it was all over the place saying our 504 rights are being threatened. Well, South Carolina's Attorney General has said, gosh, I didn't realize the impact that this was having on the disability community. And I've heard from the disability community loud and clear. And I have expressed an interest to get out of the lawsuit. And he has said that he suspects that other attorneys general will do the same. And in fact, the lawsuit might go away. Now, I can expect that we are going to see further attacks on 504 as time goes on, but I think in the short term, like for the imminent time period in front of us, that lawsuit is either going to get significantly revised or withdrawn and then probably refiled and in a way to do what they intended to do. Any follow-up questions you are welcome to ask, just like to take that one step forward. I think what will here's like my newsletter says this for tomorrow, so I'll give you like a little piece of the newsletter. So what the current administration has indicated, and President Trump has said this not only about education, but we got this like slew of executive orders and other tasks that were undertaken very, very quickly. And what President Trump had said before he was elected and has said since he's the president is that was intentional, that like he was going to come in and he was going to get right to business and blah, blah, and go, go, go. We saw that the first time he was in office. And then we saw that stuff kind of like slowed down significantly. But the intention is that people get so overwhelmed by this onslaught of like news, news, news. And, for a lot of people, they interpret it as bad news, bad news, bad news. And so eventually people just get worn down. And then we'll see a little attack to 504 or a little attack to special education laws and rights or to students with disabilities get attached to something like a sanitation bill or something. It's probably not going to be that extreme, but we'll see little like carve outs of laws coming in places where they don't make sense and they don't get as much attention because people get worn down. So what I have been doing is I have been only accessing law in a few very trusted, or not law, news, and a few very trusted resources and trying to stay on top of it. I'm literally outlining it so that I can talk about it on my social media platforms and my podcast, but in a way that like I don't get so inundated that something sneaks past me. So I think that like as a disability community with these, like you guys are doing these awesome, at least monthly calls to action. I think, if SEPTA is an organization that you really trust and that you subscribe to, kind of just saying, okay, it's going to be SEPTA and maybe these 3 or 4 other places can be effective so that we don't all get this overwhelm. I think that that's super helpful. So thanks. I had missed that one. Amanda, is the next one that you see, Amanda? I would love to exchange contact information with you. Is that okay?
Oh, I didn't see that one. That one must be direct to you.
Oh, it is.
We've had some questions about from people wanting the slides shared. Are you willing to share the slides?
Yes. Why don't I just email them to you and then you want to send them out? Or alternatively, can you download the chat and then I can do it? I don't care.
I'm happy to send it out to the attendees. That's not a problem.
Okay, awesome. So the next question is from Rachel, and it says, I've been told that ADA will cover kids with special needs in school. And that is why we won't need 504s or Department of Education. That's not true, is it? Um, so definitely not true by way of the Department of Ed. Let's talk about the potential risk of elimination of the Department of Ed. I think what Rachel is saying is that, if there's a risk that the Department of Ed goes away, um, so let's like widen this lens for just a second. So there is currently a bill filed by Representative Thomas Massey from Kentucky. That's one sentence, and it is to eliminate the Department of Education by December 26, 2026. President Trump has also kind of alluded to the fact that he would like to do that by executive order. That's impossible. Can't do it by executive order. It has to be an act of Congress, has to have 60 votes. Massey filed the same bill, and the first Trump administration didn't get any traction. A similar bill went through the House last year in the Biden administration. It was voted against by every Democrat as well as 60 Republicans in the House. So didn't get a whole lot of traction. It does seem like there's some excitement around the idea of eliminating the Department of Education right now. Time will tell if it gains any traction. But if history repeats itself, it's not going to gain a lot of traction. What would happen to the Department of Ed is really still unknown. The Trump administration hasn't said much either in the campaign nor in its current presidency. In fact, the soon-to-be Secretary of the Department of Education, Linda McMahon, said in her confirmation hearing relative to this, I don't know, I guess I need to look at it a little bit more. But that if you look at Project 2025, which is something that President Trump has referred to throughout his candidacy, and things that are getting referenced now that he is the president. What Project 2025 said, what it proposed would be to move the Department of Ed, including enforcement of most of IDEA, over to Health and Human Services, which is an entirely different governmental agency. It's the one that is currently being run by Secretary Robert F. Kennedy, Jr., who is the person that has, indicated some very controversial opinions and not research-based opinions relative to the cause and treatment of IDDs like autism, as well as access to SSRIs and all of that stuff. So those things would go there. And then the Office of Civil Rights, which is tasked with protecting students against discrimination and bullying and stuff like that within the Department of Ed. The idea in Project 2025 is to move that over to the Department of Justice, also an entirely different agency underneath the executive branch. And that's really notable because the Department of Justice is litigation oriented. So the DOJ handles litigation, and the OCR that's under the Department of Ed has been more proactive. So you just, as it was until he took office, you would alert the OCR of something like bullying. And then the OCR would come in and they would investigate and they would manage the entire plan. Like they would make a plan of action and they would monitor the plan of action. And,
I'm not sure if you're aware, Ashley, but we actually had a major finding here
I do.
from OCR just a couple years ago.
I do. And Loudoun County has one too, right?
I think so. Possibly for a different subject. Ours was COVID related. I can't remember if theirs is COVID related.
Yeah, I think Loudoun County might have one on like a disciplinary thing. Yeah. So OCR. So the impact of moving OCR, and that would have been litigation. So one or several of you would have had to have sued, and which is expensive and time consuming and extremely stressful and a whole different ball of wax. So yes. So the we do still need a Department of Education in order to run the laws and the regulations and the offices that particularly impact students with disabilities, in my professional opinion. And ADA would not cover that. 504s, like the overlap of ADA and 504 is probably not within my area of expertise. Eligibility, like who has to follow ADA, the ADA, and who has to follow 504 varies a little bit. So that's one of the reason why both of those laws exist. But listen, 504 has been in existence since 1975, 15 years before the ADA in 1990. They wouldn't exist if they overlapped all that significantly. Um, I'm going to research that because I bet you more people have that question. So I'm happy to put the answer on my social media. I'll probably do a podcast on it as well. Oh, and I have a little highlight. You know how on Instagram you can do a highlight? The highlight is called DOE Watch for all of the stories that I've done on these topics. Um, Okay. Loudoun County has a couple of findings against them related to it's IEEs. Yes. Okay. Thank you. But there are probably more. Okay. Oh yeah. So good point. 504. Oh, hi, Melissa. I didn't realize you were here. Yes. Do you want to unmute?
Go ahead.
Okay, I look terrible. That's fine.
You don't have to turn on your camera, but I think you look cute.
Hello, my friend.
Hi. So, okay. So can you go into a little bit more about 504s and ADA?
Well, just kind of big picture. The courts historically have interpreted these two laws very, very similarly. Certainly, they completely share the definitions of who qualifies underneath those rules, right? Because Section 504 incorporates the ADA amendments, actually, act on the definition of who qualifies for protection. But Section 504, in the regulations for Section 504, there are a lot more protections specifically for students to include this free appropriate public education requirement. That's in 504. So while they are very similar, there are distinctions between the two laws when you dig down to how they apply specifically to students with disabilities.
Thank you. Melissa is a special education attorney in your area, and she is incredible and so knowledgeable. So, yeah, I mean, I guess that FAPE standard is a huge, huge component to it. And is 504 stronger for disciplinary protections as well? Like
Yeah,
protection when there's a
yeah,
disciplinary matter?
yeah, I don't think ADA has disciplinary protections. That would definitely be something under 504. And again, I apologize. I'm just pulling this completely, off the top of my head, and I'm really old. So, um, but yeah, there are a lot more protections in 504. Yeah, Harold just confirmed that there's no ADA disciplinary protections. That's what I thought. Thanks, Harold.
I didn't know you were here too. Gosh, this is fun. I guess I can't see everybody. Um, oh wait, Sherry's here. Gosh, it's like a little party that we're having. It's so good to see you guys. Okay, thanks for your help.
Absolutely. Bye. Great
Um,
presentation. Thank you.
thank you, thank you. Okay, I don't see any other questions in there. Amanda, do you?
I do not. Does anybody else want to have any questions you want to raise your hand and unmute for? I'm not seeing any others come up. Now, I did have somebody message me. You mentioned Pete Wright and his workshops. So somebody did mention to me in private message that PTC, our Virginia's federally funded Parent Training Information Center, is hosting a rights law workshop in March. I will put the link to that in the chat. When you register for one of these events, typically you get the books that Ashley was putting up as part of the registration fee. You will receive those in the mail prior to the workshop. So I'll put that link in the chat before we all head out.
Yeah. And I think, I mean, you guys have such a wonderful group as well, but I think going to those things is as beneficial to sit through it and listen to it. In his one day, he has you, I doubt I have it, but he has you like go through the law and basically highlight the like topic sentences, which is like super helpful just to get you oriented with the law. And it's something that you probably wouldn't do otherwise, you know? So it's really helpful. And then you get like his little advocacy tips throughout the day, which is beneficial. But also like coffee time and the lunchtime networking and like storytelling can be really beneficial as well. So I think the more immersive the experience is for you, the better. Also, I highly recommend going to that if it's accessible.
Yes, absolutely. I don't know if this one, Kelly, do you know if this one is in person or virtual? The one that I attended, it was during COVID and it was virtual.
It's virtual.
It is virtual?
So, yeah.
Okay.
There is one other question. The question is, if we want the written documentation relative to our child, how would we request that documentation? So, there is a federal law called FERPA, which is kind of like the HIPAA of education laws. And so your district probably has a FERPA release. So if you wanted it sent to somebody else, you would you would just go in and sign the FERPA release and have it sent someplace else. If you're asking for them for yourself, then you can simply send a request into the district and say, hey, I would like a copy of my child's entire educational file, and they will send it to you. I usually list out what I want specifically because I did it when my child was going to kindergarten when we had a dispute with our school district. And I literally got 5,000 pieces of paper. It more than filled a paper box because, you know, they weren't like in the little nice condensed reams of paper. So, you know, IEPs, evaluation reports, progress reporting documents, report cards. You can ask for specific communication if you want that. You can ask for everything if you want it. And I bet Melissa's about to tell us whether or not it's free and how they have to do it because she showed her camera.
Oh, right. I just wanted to say I posted a link to an article we have on our firm website about this issue, but I was just going to mention, Ashley, since you aren't in Virginia, actually their Freedom of Information, the Virginia Freedom of Information Act was modified about 2.5 years ago that made all records, student records, free. So the parents
Awesome.
cannot be charged for those records in Virginia. It's kind of a unique thing that we have, but there's a whole bunch more on that for folks on that link I posted to the chat.
I was going to ask you because in the question it referenced FOIA, and so I figured that your FOIA had made them free. Okay.
Yes, and we actually can get a lot like emails and that kind of thing. It's a very in Virginia now. It's a very powerful law for parents and a great tool in their toolbox.
It really is. And you know, I have a whole other talk that I talk about like getting organized and communication and that kind of thing. And I highly recommend that you save it in two ways. Like I actually had to amend my background because somebody brought me a tub of documentation today. And it like hurt to put it on the floor, but I don't want you looking at it. So like I do think it's really good to have them on paper because I just think it's like you can organize it. I do this color coded paperclip method. But then I also recommend that people scan stuff in and that you file it chronologically that way by date. So like today would be 2025 0224, February 24. And then things will save in order. And if you consistently call them the same thing, right? Like IEP draft, IEP final, IEP with my notes, stuff becomes really easy to find. And then you can search for it in your computer. So I think it tells a story if you have it on paper, but it also is really easy to find if you have it electronically. Definitely a do as I say, not as I do thing, because I could also show you mine that are like an explosion.
I do want to respect everybody's time. I see we do have one more question, so I want to ask you, Ashley, are you okay taking it, or we're a little past time?
Yeah, I'm okay. And please don't feel like it's bad manners if you guys drop off to go watch Gossip Girl or something.
Okay, this is the last question then. Are there laws about what materials the school must provide, like work samples, to be able to compare home mastery versus progress reports?
It sounds like FOIA does now request that sort of thing. So, yes, I would definitely familiarize yourself with that. And Melissa has that article that is directly above your question, Stephanie. So I think that would be a good thing to ask for. But, there's no time like the present to start saving what you do get, right? And so anything that comes home in report cards or regular progress monitoring time is important. And if something isn't accessible to you, a lot of times I read progress reports that are just in paragraph form. And people are like, gosh, they share those awesome graphs at the meeting. Why don't I get graphs? Ask for the graphs. They're there. They're literally already in the computer. All they have to do is generate them. So, if you communicate regularly and if your IEP team is functioning as a team as it should, then that's no big deal to be like, hey, you know what? Thanks so much for sending over the progress. I do have some comments. I'm really excited to talk about it. But it would make a whole lot more sense to me if I could have the graphs like we share at IEP meetings. Would that be too much trouble to send over? Then you get the graphs and then you can respond back to the progress reporting. But like if there's one thing that I have to say relative to, that's actually kind of a nice segue, because if there's one thing I have to say relative to these changes that we're seeing at the federal level and changes that we're anxiously awaiting at the federal level, it would be that there really seriously is no time like right now to start working on collaboration, to start provoking a lot of empathy in your IEP team, and to start those teamwork strategies in order to make things better, right? Because I don't think that kids on IEPs are going to lose all their protections or anything. But to the extent that protections are lessened, or that funding and staffing is lessened, and that special education is challenged in any way, we might have to advocate for our schools and our school divisions to do things because they want to and because it's the right thing, as opposed to doing things because it is mandated by the law. And so, really starting to build those relationships, in my opinion, is a super duper important thing right now.
Agreed. And we've talked about that a lot ourselves in SEPTA. I believe we have our board members have submitted a proposal for the family summit on that kind of collaboration topic. I think I could be wrong. Sorry, Diane and Michelle, if I'm wrong. But the family summit that Michelle and Diane mentioned at the beginning will have a lot of talk about that collaboration and inclusivity. So
That's
keep
awesome.
an eye out for that summit. Thank you so much for your time tonight, Ashley. This was a great presentation. We really appreciate you coming out to join us tonight.
Good. Thank you. It's nice to see you all. Thanks. And thanks for all the hard work you guys are doing as well.